Charles Whitfield did not look up from his notes when they walked in. He heard the door. He heard the footsteps. Then he heard the cardboard box scrape against the defense table, and that made him look. He took them in slowly, 3 young black people. Cheap clothes, a rubber-banded stack of folders printed at a copy shop, no briefcases, no associates, nothing that belonged in his courtroom. He set down his pen. He picked up his coffee. He turned to his associate and smiled the way a man smiles when he has already decided how the morning ends. 3 black kids and a cardboard box, he said loud enough for the first 2 rows to hear. I've faced Harvard-trained prosecutors. I've faced sitting judges. And today they send me uneducated trash who learned the word plaintiff on YouTube. The associate laughed quietly. Whitfield wasn't done. He looked directly at Simone, the one standing closest, and tilted his head like she was a curiosity in a museum. Sweetheart, the library's 2 blocks east. You might want to start there before you try a courtroom. Then he straightened his cufflinks, turned back to his notes, and said to no one in particular, This'll be over before lunch. These people never last past the first motion. Someone in the gallery laughed. The clerk did not look up. The bailiff studied the wall. Not one person said a word. In less than 2 hours, Charles Whitfield would be asked one question, a single question from the youngest of the 3. And the silence that followed would end his career. Stay with this story. Drop your city, and the time where you are. I want to know who's watching. And if you believe the truth, still has a voice, hit subscribe. What happens next will stay with you. Bridgeport, Ohio sits 40 miles southeast of Columbus, wedged between 2 stretches of interstate and a river that has not run clean since 1987. It is the kind of city that appears on maps, but rarely in conversation. 80,000 people. 2 high schools, 1 hospital, and 1 employer that matters more than everything else combined. Meridian Industrial. Meridian. The plant covers 43 acres on the south end of town. Its smokestacks are visible from every neighborhood in Bridgeport. It employs 3,400 workers, pays an average of $19 an hour, and has been the single largest taxpayer in Crestfield County for 31 consecutive years. When Meridian does well, Bridgeport does well. When Meridian cuts shifts, the restaurants on Main Street start closing on Mondays. The city and the company have been tangled together for so long that most people stopped noticing where one ends and the other begins. Leonard Webb had worked inside that plant for 22 years. He started at Meridian in 2001, the year the Triplets were born. He began as a floor technician in the quietest section of the plant, and worked his way into maintenance engineering without a college degree, without a mentor, and without a single person above him who looked like him. He learned by watching, by reading equipment manuals at the kitchen table after dinner, by asking questions of the machines themselves when no one would answer his questions to their faces. His colleagues called him the man with the hands, not as a nickname given lightly, but as a fact stated plainly. There was not a piece of equipment in that plant Leonard Webb could not diagnose before he ever reached for a wrench. He was also, for the last 14 months of his life, the most ignored man at Meridian Industrial. In January 2022, Leonard filed his first safety complaint about Zone B7, the high-pressure compression section on the plant's west end. The complaint was specific and technical. A pressure relief valve on the primary compressor line was showing irregular discharge cycles consistent with internal seal degradation. He requested an inspection. Management responded, acknowledged. No action required at this time. He filed again in March, in June, in September. Each complaint more detailed than the last. By his 8th filing, he had documented not just the failing valve, but a disabled warning sensor manually overridden and never restored, and a section of hydraulic pipe that exceeded its certified service life by 6 years. He attached photographs. He attached pressure log printouts. He cited the exact OSHA standard being violated by code number and subsection. The response from Meridian every time was the same. Acknowledged. No action required at this time. On March 15, 2023, at 7:42 in the morning, Zone B7 exploded. Leonard Webb was inside. The blast collapsed 2 internal walls and sent a section of pipe 60 feet through the air. 2 other workers were injured. Leonard did not survive. The Bridgeport Gazette covered the story on page 4 below a piece about a local high school's baseball season. His name appeared once in the second paragraph. No one from Meridian's leadership issued a public statement. Gloria Webb was 58 years old, a nursing aide at Bridgeport Memorial, and had been married to Leonard for 31 years. She learned what happened from a police officer at her front door at 8:15 that morning. She was still in her scrubs car keys in her hand, ready to leave for the day shift. She stood in the doorway for a long time without moving. Then she went inside and sat at the kitchen table and did not move for 4 hours. 3 days later, a Meridian representative arrived at the house with a sympathy card and an envelope containing a check for $47,500 and a document titled Release and Settlement of All Claims. The representative explained in a practiced and gentle voice that this was the company's way of supporting the family during a difficult time. All Gloria needed to do was sign at the bottom. Gloria read the document once, read it again, set it on the kitchen table, and told the representative to leave. The check sat untouched on that table for the next 6 weeks. The triplets came home the same weekend. Darius drove from Columbus, where he worked as a data analyst for a mid-size insurance firm, a man who read numbers the way other people read novels fluently and without effort. Simone drove from the same city where she had spent 2 years as a paralegal at a small plaintiff's firm, learning the shape of a lawsuit from the inside without ever standing before a judge. Marcus drove from the west end of Bridgeport itself, where he ran diagnostics and engine repairs at a commercial truck garage and understood in his hands, and not just his head, exactly what pressure and heat and metal fatigue could do to a machine when someone chose not to maintain it. They sat at the kitchen table with Gloria, and they began to understand slowly, and then all at once, what their father had left behind. In his home filing cabinet, organized by year, and subject with the same quiet precision he brought to everything, were copies of all 11 safety complaints. Each one stamped, filed. Each one marked in Leonard's handwriting with the same 2 words, no response. Simone pulled the last one dated March 10th, 2023, 5 days before the explosion, describing in clinical detail the exact valve that failed the exact sensor that had been disabled and the exact pipe section that had exceeded its service life. She read it once. She set it down. Then Meridian's legal team sent over a discovery packet through their original attorney, James Okafor. Inside was a document Meridian called their primary defense, a signed safety waiver dated November 18, 2021, bearing Leonard Webb's name. Proof they claimed that he had been fully informed of the risks and accepted them voluntarily. Simone read the waiver, read it again, held it up close. Then she called across the room, "Darius, come look at this signature." James Okafor withdrew on a Tuesday. He had been their attorney for 6 weeks. He had reviewed the safety complaints, filed an initial response to Meridian's motion to dismiss, and told the triplets twice that this was a strong case, that the documented complaints alone established a clear record of corporate negligence. They had believed him. Darius had started sleeping again for the first time since the funeral. Then Okafor called Gloria at 7:30 on a Tuesday morning, and his voice was flat and rehearsed in the way that voices become when a person has been practicing what they are about to say. Mrs. Webb, I have to withdraw from your case. Meridian has offered me a position as their in-house general counsel. The compensation is significant, and I have a family to consider. I'm truly sorry. I am. Gloria said, You are going to work for the people who let my husband die. Disgawahin. Okafor did not answer that. He said he was sorry one more time. Then he hung up. The Triplets spent the next 3 weeks calling every law firm in Bridgeport and Columbus with any experience in workplace injury or wrongful death. They made a list of 23 firms and worked through it methodically, the way Darius approached every problem top to bottom, no skipping, no assumptions. The results were as follows. 14 firms declined without explanation. 6 firms quoted retainer fees ranging from $50,000 to $85,000 payable up front before any work began. Gloria's monthly income as a nursing aide was $3,100. 2 firms said they would consider the case and never called back. One attorney, a man named Gerald Fitch with a flagpole in front of his office and a framed photograph of himself shaking hands with a senator, told Simone over the phone that Meridian had a $4 million legal defense fund, 3 partner-level firms on retainer, and unlimited patience. You don't want this fight without resources, he said. Negotiate. They'll give you more than what's in that envelope. Simone thanked him and hung up. Legal aid was not an option. Their intake coordinator reviewed the case and explained apologetically that complex civil wrongful death suits exceeded their current capacity. The waiting list was 8 months long. The statute of limitations would not wait 8 months. On a Thursday evening, Marcus came home from the garage to find the rear window of his truck shattered in the parking lot. No note, no camera, just broken glass on the back seat, and the particular silence of a message that does not need words. 2 days later, Simone answered a call from a number she did not recognize. A man's voice, unhurried and calm, said, Your father died because of the choices he made. You should think carefully about the choices you're making. Then the line went dead. Simone sat still for a moment. Then she pressed the button to save the recording to her cloud backup, walked to the kitchen, and made coffee. She called the Bridgeport Police Department. An officer took down the information and issued a case number. There was no follow-up investigation. That same night, Marcus spread every document from Leonard's personnel file across the living room floor of Gloria's house. All 22 years of paper employment contracts, performance reviews, payroll confirmations, training certifications, disciplinary records, commendations, and equipment sign-off sheets. 847 pages. He laid them in chronological order, oldest to newest, covering every inch of carpet from the couch to the television. Then he sat cross-legged in the middle of it and started looking at signatures. Marcus was not a lawyer. He was not a forensic examiner. He was a mechanic. A man who had spent 15 years diagnosing problems that other people missed because they were looking at the whole machine instead of the one component that was wrong. He looked at signatures the same way he looked at engines. Leonard Webb's signature, replicated 847 times across 22 years, was consistent in every measurable way. The baseline of every letter angled slightly upward to the right. The opening loop of the capital L was wide and open, curving outward before curling back. The descending stroke of the final B in Webb pulled upward at the end a clean, controlled flick that left a small hook above the baseline. These were the involuntary habits of a man who had been writing with his right hand his entire life. Marcus picked up the safety waiver. He held it next to the most recent personnel document in the pile, a training certification from October 2022, 5 months before the waiver's date. The baseline on the waiver ran flat with a slight leftward tilt. The loop on the L was narrow and closed, pressing inward rather than opening out. The final stroke on the B pulled downward and curved under the baseline, a gesture that belongs to the left hand, not the right. Marcus stayed on the floor without moving for a long time. Then he said quietly to the room, "He didn't sign this." Darius came in from the kitchen. Marcus showed him both signatures without saying anything else. Darius looked at one, then the other, then back. He reached for his laptop. While Marcus sat with the signatures, Darius opened his email. Among the usual notifications was one from an address he did not recognize, a Proton Mail account, a string of random letters with no name attached. He almost moved it to spam. Then he read the subject line. "Check Gary Tatum's employment end date." That was the entire message. No explanation, no signature, nothing else, nothing. Darius stared at the screen. Then he typed the name into the Ohio Department of Commerce public database and waited for the results to load. The morning of the first preliminary hearing was cold and gray in the way that Ohio mornings in October tend to be not dramatically cold, just the steady flat cold of a season that has made up its mind. The triplets arrived at the Bridgeport Civil Courthouse at 8:20, 40 minutes early. They carried the cardboard box, the printed folders, and their father's 11 safety complaints in a plastic sleeve Simone had purchased at an office supply store. Gloria sat in the second row of the gallery in her church clothes, her hands folded in her lap, and did not look at anything in particular. Charles Whitfield arrived at 8:35 with 2 associates, a rolling file cart, and the particular ease of a man who had been in this building so many times, it had started to feel like a second office. He set his things at the plaintiff's table, arranged his documents, poured coffee from a thermos, and did not acknowledge the 3 people across the aisle from him until the bailiff called the room to order. Then he looked, and he said what he said loud enough for the front 2 rows to hear it. 3 black kids and a cardboard box. I've faced Harvard-trained prosecutors. I've faced sitting judges. And today they send me uneducated trash who learned the word plaintiff on YouTube. His associate laughed into his collar. Whitfield was not finished. He looked directly at Simone, tilted his head with the mild curiosity of a man examining something unexpected in the wrong place, and said, "Sweetheart, the library is 2 blocks east. You might want to start there before you try a courtroom." Then he straightened his cufflinks and spoke to no one in particular. "This'll be over before lunch. These people never last past the first motion." Nobody in the gallery corrected him. Judge Patricia Hollins entered at exactly 9 o'clock. She was 58 years old, had served on the Crestfield County Civil Bench for 19 years, and had seen every variety of case and character this building could produce. She took her seat, reviewed the docket, looked once at the defense table, without any readable expression, and said, "I see the plaintiff is proceeding pro se. I'll allow it. Let's begin." Whitfield filed his first motion before the opening statements were complete. Motion to strike 3 of the safety complaints from the evidentiary record on foundation grounds. The originals were personal copies not certified through Meridian's official records system. Hollins granted it pending authentication review. His second motion to establish Leonard Webb's contributory negligence as the threshold question for the entire proceeding, meaning the court would need to determine Leonard's own role in his death before any corporate liability could be addressed. Hollins granted the framework, not the conclusion. His third motion, to limit the scope of discovery to documents dated within 18 months of the incident. Hollins granted it with a modification 24 months. His fourth motion to exclude Gary Tatum's name from any witness list until his relevance to the case was established through direct testimony. Hollins deferred. His fifth motion to compel the plaintiffs to submit a formal evidentiary exhibit list within 10 days or face sanctions. Hollins granted it. When Simone rose to respond to the contributory negligence motion, she had 3 minutes. She used all of them. She cited the specific OSHA standard Leonard had referenced in his complaints, cross-referenced the Ohio Revised Code on employer liability for known hazardous conditions, and argued clearly, without notes, that a worker who files 11 documented safety complaints about a piece of equipment cannot, as a matter of law, be held primarily responsible for the failure of that equipment. Whitfield interrupted twice. Hollins allowed both interruptions. When Simone finished, Whitfield turned to his associate and said just under his breath, but not under enough, "She memorized some statutes. That's almost adorable." Darius wrote a number on the edge of his notepad and slid it to Marcus 4-1. Whitfield had won 4 of the 5 motions. They had won a partial modification on one. Marcus wrote underneath it, Round 1. The hearing ended at 11:20. Gloria was waiting in the hallway, standing very straight, her purse strap held with both hands. The 4 of them walked to the parking lot without speaking. In the car, Darius sat in the passenger seat and looked at the courthouse through the windshield for a moment. Then he said, "We need the handwriting analysis established as proper science before the next session. If they can exclude Soto's affidavit, we lose the signature argument entirely." Simone said, "I know." Marcus said, "We also need to know who Gary Tatum is, and we need to know it before Whitfield does." Simone started the car. Nobody spoke for 2 blocks. Then Gloria from the back seat said quietly, "Your father filed those complaints knowing nobody was going to listen. He did it anyway. Every time." She looked out the window. "You all do the same?" Back at the house, Darius opened his laptop and pulled up the Ohio Department of Commerce database. He had searched Gary Tatum's name the night before and found his certified inspector license record. Now he needed one specific piece of information, one date, and he needed it to line up with the date on Meridian's safety inspection report. He found it in 11 seconds. He read it twice. He closed the laptop slowly. Then he opened it again and read it a 3rd time, because some things need to be confirmed before they become real. Gary Tatum's official last day of employment at Meridian Industrial was February 28, 2023. The safety inspection report he had allegedly signed was dated March 1st, 2023, one day after he was gone. The signature thread and the Gary Tatum thread ran parallel for 4 days before they converged. Marcus started with the paper. He had already spent one night on Gloria's living room floor with 847 pages of his father's employment records. Now he reorganized them not by date, but by document type. Every performance review in one stack, every equipment certification in another, every training sign-off in a 3rd. He was looking for consistency, the kind that accumulates over decades without a person consciously choosing it, the kind that becomes as involuntary and revealing as a fingerprint. Leonard Webb's signature, reproduced across 22 years of institutional paperwork, did not vary in any significant way. The capital L opened wide its loop, curving outward to the right before returning. The terminal stroke on the B at the end of Webb pulled upward, finishing with a small rightward hook above the baseline. Every line of text leaned slightly upward to the right. These were not stylistic choices. They were the involuntary geometry of a right-handed man who had been signing his name the same way since he was old enough to hold a pen. Marcus placed the safety waiver beside a performance review dated October 2022, 13 months before the waiver's claimed signature date, and studied them together under the kitchen light. The waiver's L was narrow, its loop pressed inward, closing on itself. The terminal stroke on the B curved downward and tucked below the baseline. The lines of text ran flat with a leftward lean. He was not a forensic examiner. He was a mechanic trained by 15 years of practice to find the single component that was wrong when everything else appeared intact. This component was wrong in every way that mattered. The person who signed Leonard Webb's name on that waiver was left-handed. Leonard Webb had been right-handed every single day of his working life. Simone contacted Professor Elaine Soto at Bridgeport State University on a Wednesday evening through the faculty directory. She sent a brief email attaching scanned images of the waiver and 2 comparison documents and asked for 30 minutes. She offered nothing in return because there was nothing to offer. Soto responded at 6:08 the next morning. "Be at my office at 2. Bring the originals." The professor was a forensic chemist 21 years into research on how materials behave under physical force. She examined the waiver under a digital magnification scope for 38 minutes without speaking. The triplets stood against the wall and waited. When she set the scope down, she did not frame what she said as an opinion. The downstroke pressure throughout this signature is consistently heavier than the upstroke. That is the defining characteristic of a left-handed writer under normal grip conditions. Your father's documents show the opposite pattern without a single exception across 2 decades. He did not sign this waiver. She agreed to provide a sworn affidavit, pro bono. She offered 1 sentence of explanation. Her own father had worked in a facility not unlike Meridian for 30 years and had filed complaints of his own that no one ever read. While Marcus and Simone worked the signature, Darius worked Gary Tatum. The Ohio Department of Commerce database had confirmed the essential fact Tatum's employment at Meridian Industrial ended on February 28, 2023. The safety inspection report bearing his signature was dated March 1, 2023. 1 day after his last official workday. 1 day after Meridian no longer had any legal reason to preserve his access to his own notary stamp. Darius located a residential address through Ohio public property records. On a Saturday morning, Marcus drove out alone and did not knock on the door. He walked to the mailbox and left a sealed envelope containing 2 items, a photocopy of the Ohio DOC record showing Tatum's termination date, placed directly beside the front page of the inspection report bearing his names, and a handwritten note of 2 sentences. "We are not here to harm you. We are here because our father is dead, and your name is on a document you could not have signed." Tatum did not call that day. He did not call the next day either. On the 3rd evening at 11:47 p.m., Simone's phone received a text from a number she did not recognize. "I didn't sign that report. I was already gone. They used my old notary stamp. It was in my desk drawer when they walked me out, and they never gave it back despite my written request." Then after a pause of 2 minutes, a second message, "I'm scared." Simone typed 1 sentence back. "You should be more scared of staying silent." Gary Tatum agreed to provide a sworn affidavit. He would not appear in court, but he would sign a notarized statement confirming that he had not signed the March 1st inspection report, that his stamp remained in his desk at Meridian when he was terminated, and that it was never returned. The affidavit was signed and notarized within the week. That same evening, Gloria went to the bedroom closet and returned with a shoebox she had not opened since the funeral. Inside, Leonard had kept his own copies of every safety complaint, separate from the official submissions annotated in his handwriting, with brief observations about what he had seen and what he had expected. Most annotations were clinical and precise. The notes of an engineer documenting variables. The last complaint dated March 10, 2023, had 1 additional line at the bottom that was not part of the standard form. Leonard had written it in the margin in slightly smaller letters than the rest, as though he had added it after the fact, and had not been entirely sure he wanted it there. "If this one doesn't get a response, somebody is going to get hurt. Going to get." Simone read that line standing at the kitchen table. She did not sit down. She read it twice. Then she looked at the date, 5 days before Zone B7 exploded, and she understood with the full weight of it that her father had known exactly what was coming and had tried one more time to stop it through the only channel available to him. Nobody had answered. They had 2 weeks before the next hearing. They used all of it. The three of them divided the work the same way they had divided everything since childhood. Not by negotiation, but by instinct, each moving toward what they could do best without anyone needing to say it aloud. Darius took the evidence chain. He built a spreadsheet with 400 rows, one for every document in their possession, logging timestamp source chain of custody and the specific legal theory each document supported. He color-coded by category red for documents directly impeaching Meridian's defense, yellow for supporting context, green for authenticated exhibits ready to submit. By the end of the first week, the red column alone had 31 entries. He printed the spreadsheet, laminated it, and taped it to the wall above the kitchen table where Leonard's safety complaints had sat for months. Simone took the law. She spent 4 consecutive nights reading Ohio wrongful death statutes, workplace liability standards, evidence admission rules for pro se plaintiffs, and every appellate decision she could locate that touched on forged instruments in civil proceedings. She had 2 years of paralegal experience, enough to know the architecture of a lawsuit, enough to know where the weak points were. She took notes on index cards organized by argument type, building a response to every objection Whitfield had already filed, and every motion she expected him to file the next. Marcus took the machines. He spent his evenings researching the specific class of pressure relief valve in Zone B7, reading OSHA incident reports from comparable industrial facilities, and consulting with engineers on professional forums under a pseudonym. By the end of week 1, he could explain in terms a jury could understand exactly what happens when a pressure relief valve with degraded seals is subjected to a sustained load. He could explain why the sensor override made the failure not just possible, but inevitable. He could explain why Leonard's complaints had identified the correct problem in the correct sequence, with enough lead time to have prevented every part of what followed. Whitfield filed 2 new motions on the first Friday of the preparation period. The first motion sought to exclude Professor Soto's affidavit on the grounds that a forensic chemist lacked sufficient qualification to opine on handwriting characteristics. The motion cited 3 cases, all of them from federal courts in other districts, none of them directly on point. Simone read it twice and began pulling peer-reviewed literature on pen pressure analysis within the hour. The second motion sought to exclude Gary Tatum's affidavit, entirely characterizing it as hearsay from a disgruntled former employee with a documented grievance against the company. Darius noted that Tatum had never filed a formal grievance. They had his personnel record from discovery and flagged it as a misrepresentation to the court. He added it to the red column of the spreadsheet. Then, on a Tuesday morning, Gloria received a letter from Meridian's HR department. It was brief and formatted like a standard administrative notice. Due to the pending litigation, her late husband's pension payments and survivor benefits were being suspended, effective immediately pending legal resolution of all outstanding claims. The monthly amount being withheld, $1,847. Gloria read the letter at the kitchen table, folded it in half, and placed it face down beside the still untouched check for $47,500 that had been sitting there since the week of the funeral. "They're trying to break us before we get there," Darius said. Gloria looked at him for a moment. "Then don't take long," she said, and stood up to start dinner. The response to Whitfield's motion on Soto's affidavit took Simone 3 days to write. She located 7 peer-reviewed papers on lateral pen pressure analysis as an indicator of handedness, 5 of which were co-authored by certified forensic document examiners using methodology identical to Soto's. She argued that Soto's doctorate in materials science, specifically her research into substrate interaction and directional force, made her more qualified, not less, to speak to the mechanics of how a pen contacts paper. She cited the Ohio Rules of Evidence on expert witness qualification and attached the papers as exhibits. She filed the response the morning before the next session. That night, the four of them sat in Leonard's kitchen after dinner. Gloria washed the dishes. Marcus dried them. Darius reviewed the exhibit list. Simone sat at the table with a yellow legal pad and wrote out every question she intended to ask Dr. Philip Mercer Meridian's expert witness, former GBI analyst, $800 per hour consultant when he took the stand. She wrote for 2 hours. She crossed out questions. She rewrote them. She arranged them in order, then rearranged them, thinking about sequence the way a person thinks about the order of locks on a door. The goal was not to overwhelm the witness. The goal was to reach one specific admission, one acknowledgement that would make everything else collapse on its own weight. At midnight, midnight, she stopped writing. She read back over the full list from the beginning. Then she stopped at one question near the bottom of the 3rd page. She drew a line under it with her pen. Then she drew another line. Then she set down the pen and circled the question 4 times until the ink was thick enough to see from across the table. That was the one. Not because it was the most complicated question on the page, because it was the simplest. Because if Mercer answered it honestly, the defense would crack at its foundation, and if he answered it dishonestly, the court would know it within 60 seconds. She closed the legal pad. She turned off the kitchen light. She did not tell her brothers which question she had circled. She did not need to. Morning was 6 hours away. The courtroom was fuller than the last time. 2 reporters from the Bridgeport Gazette occupied the end seats of the 2nd row, with notepads already open. A local blogger sat in the back with a Canon camera balanced on his knee. 4 men in work clothes, Meridian employees, current or former. It was impossible to say sat together near the aisle with the particular stillness of people who have come to watch something they already know the ending of, but need to see with their own eyes regardless. The young paralegal who had attended the first hearing was back in the 3rd row. Now, instead of the 6th, and she had not brought a tablet. She was simply watching. Gloria Webb sat directly behind the defense table in her church dress, a small gold pin on her lapel, with Leonard's photograph from the year he made senior technician. Justice Clara Pemberton, who had driven 40 minutes from Columbus without being asked, sat 2 seats away with her hands in her lap, and said nothing to anyone. Charles Whitfield wore charcoal today. He appeared, as he always appeared, completely undisturbed. He called Dr. Philip Mercer as his first witness. Mercer was everything Whitfield needed him to be, 61 years old, 31 years at the Ohio GBI, before transitioning to private consulting, a bearing of professional authority that filled the witness box the way a piece of furniture fills a room. Whitfield led him through his credentials at length. Then he showed him a printed copy of the March 1st safety inspection report, asked him to confirm he had reviewed it as part of his analysis, and moved to the central question. Dr. Mercer, based on your comprehensive review of Meridian's safety records maintenance logs, and the March 1st inspection report, in your expert opinion, was Zone B7 in compliance with applicable OSHA standards prior to the March 15th incident. Yes, Mercer said. His voice was flat and certain, the voice of a man who had answered this category of question hundreds of times. The inspection was thorough and the zone was in full compliance at the time of the report. And was Leonard Webb's death consistent with operator error? In my opinion, yes. The evidence indicates he entered a restricted zone during an elevated pressure sequence without the required secondary authorization. No further questions. Whitfield sat. He did not look at the defense table. Darius stood up. He carried one printed sheet of paper and nothing else. He walked to the open space in front of the witness box, stopped, and looked at Mercer without speaking for a moment, not as a tactic, but because he was thinking about sequence, about the order of locks on a door, exactly as Simone had been the night before. Dr. Mercer, good morning. Good morning. You testified that Zone B7 was in compliance as of March 1, 2023, based in part on the inspection report filed that date. That is correct. Dr. Mercer, in your review of that report, did you independently verify that the inspector whose name appears on the document was actively employed by Meridian Industrial on the date the report was filed? The room shifted. It was not a dramatic shift. It was the kind that happens when a question arrives that no one expected, and everyone immediately understands the weight of. Mercer glanced toward Whitfield. Whitfield was looking at the carpet between his shoes. I reviewed the report as presented. Inspector credential verification is typically handled by yes or no, Dr. Mercer. Did you verify that Gary Tatum was employed by Meridian Industrial on March 1, 2023? A pause of 4 full seconds. I did not independently verify his employment status on that specific date. Thank you, Darius said. No further questions. He sat down. He did not press further. He did not turn to his siblings or make any gesture toward the gallery. He placed the one sheet of paper flat on the table and folded his hands over it. The silence in the room completed what the question had started. Whitfield was on his feet immediately. Objection, Your Honor. Counsel is implying facts, not in evidence. There is no foundation for the suggestion that Mr. Tatum was not employed on March 1st. Darius spoke without standing. Your Honor, we have in evidence a certified employment record from the Ohio Department of Commerce and a sworn affidavit from Mr. Tatum himself, both previously submitted. We are prepared to introduce them formally at this time, if the court requests. Judge Hollins looked at Whitfield, then at the documents Darius had placed on the edge of the bench rail. I would like to see those records, Mr. Carter. Mr. Whitfield, your objection is overruled pending review. Whitfield attempted a redirect. He asked Mercer whether his professional conclusion about Zone B7's compliance could stand independent of the March 1st report, based on other documentation in his review. Mercer began to answer. Hollins interrupted him with a question of her own, something she did rarely, and which made the gallery sit forward. Dr. Mercer, if the inspection report cannot be authenticated because the signatory was not employed by the company on the date of the signature, does your expert opinion regarding Zone B7's compliance prior to March 15th still stand as stated? Mercer was quiet for 4 seconds, then 5. It would require significant reassessment. The room did not erupt. It exhaled. A slow collective settling like a building adjusting to a shift in its foundation. The 2 reporters were writing. The 4 workers near the aisle had stopped being still. The young paralegal in the 3rd row pressed both hands flat against her thighs and stared straight ahead. During the afternoon recess, one of the 4 workers in work clothes walked past the defense table, set a folded piece of paper beside Darius's folder without looking at him, and continued out the door. Darius opened it under the table. 6 handwritten lines. 3 canceled. Zone B, 7 work orders from January 2023. Each personally halted by VP Robert Crane. The worker claimed to have the emails. A phone number was written at the bottom. Darius folded the paper and placed it in his shirt pocket. We need Crane on the stand, he said quietly without looking up. Whitfield's going to put him there himself. He as to those canceled work orders need an explanation. He smoothed the edge of the folder. And when he does, we need one question ready. Just one. Across the table, Simone was already writing. The second evidentiary session opened on a Thursday morning with 12 people in the gallery instead of 8, and 2 of them were taking notes on laptops. Whitfield moved immediately on the Soto affidavit. He had spent his motion brief citing 3 federal cases from other districts arguing that a forensic chemist lacked sufficient qualification to render expert opinion on handwriting characteristics. His language was confident and dismissive in the particular way of a man who files the same category of motion many times a year and expects it to land the same way it always has. Simone stood up with a manila folder tabbed with numbered dividers. Your Honor, pen pressure analysis as an indicator of handedness is established methodology in forensic document examination. Professor Soto holds a doctorate in materials science with 21 years of published research into substrate interaction under directional force, precisely the mechanical process by which a pen contacts paper. Of the 7 peer-reviewed studies in this folder, 5 are co-authored by certified forensic document examiners applying identical methodology to the one Professor Soto used. 3 of those 5 have been cited as authority in Ohio State Court proceedings. She placed the folder on the bench rail. Hollins picked it up, opened the first tab, and read for 90 seconds without speaking. I'll allow the affidavit. Wait is for the jury, Mr. Whitfield. Next matter. Whitfield had prepared a secondary argument. He introduced Leonard Webb's 2019 medical record from Meridian's employee health file, a hairline fracture to the right index finger sustained in a routine equipment check. Recovery documented at 3 weeks. His implication was clear. A man who had injured his dominant hand might temporarily adapt to writing with the other, introducing variability that invalidated any handedness analysis. Marcus stood up before Darius could reach for his notes. It was the second time he had spoken in a courtroom. Your Honor, the medical record Mr. Whitfield is citing shows full clearance for return to duty on March 3, 2019. The safety waiver bearing my father's alleged signature is dated November 18, 2021. 2 years and 8 months after that clearance. Every personnel document in my father's file between March 2019 and the date of the waiver shows his standard right-hand signature without variation. The injury argument has no evidentiary connection to the date in question. He sat down. The gallery was quiet. Hollins looked at Whitfield. Response. Whitfield said nothing for 3 seconds, the first pause of that length anyone had heard from him in 2 hearings. The defense maintains its objection. Noted. Overruled. Continue. The 11 safety complaints, all authenticated through dual-source confirmation, Gloria's originals and Meridian's own records obtained through discovery, were entered into the evidentiary record in full. Hollins read the filing dates aloud as each was logged. When she reached the final complaint dated March 10th, she paused on Leonard's handwritten annotation. She did not read it aloud. She simply held the page for a moment longer than the others, before setting it with the stack. The 3 canceled Zone B7 work orders came next. Each bore the notation, "Hold per VP Crane," in the same handwriting. Darius had cross-referenced the handwriting against Crane's signature on 2 internal memos obtained through discovery, attached the comparison as a supporting exhibit, and requested the documents be entered as evidence of direct executive knowledge of the maintenance backlog. Whitfield objected on relevance grounds. Hollins overruled him. During the afternoon recess, Whitfield requested a brief chambers meeting. He was inside for 22 minutes. When he came out, his posture was unchanged. But the pocket square that had been folded in a sharp point that morning had been pushed flat, and the top button of his shirt was no longer visible beneath his tie knot. These were small things. Simone noticed both. Gloria watched the session from the second row without expression. When Darius glanced back at her during the work order admission, she gave him one small nod, not of encouragement, but of confirmation. The kind of nod that says, "I see it. Keep going." At the close of the session, Hollins announced the schedule for the final hearing. Full witness testimony. Closing evidentiary arguments. She looked at both tables when she said it, which was unusual. Typically, she looked at the plaintiff's side. On the drive back, Marcus asked the question that had been in the room all afternoon without anyone saying it. Is Whitfield going to put Crane on the stand? Darius had been thinking about the same question for 6 hours. He has to. The canceled work orders are in the record. They have Crane's name on them. If he doesn't put Crane up to explain them, the jury draws its own conclusion. And whatever conclusion they draw will be worse than the truth. Then Crane testifies, Simone said. Then Crane testifies. Nobody spoke for another mile. Then Gloria from the back seat reached forward and placed her hand briefly on Simone's shoulder, the same way Marcus thought that she used to place her hand on Leonard's shoulder when he was worried about something and trying not to show it. She did not say anything. She did not need to. That evening, Simone sat at the kitchen table with her legal pad and rewrote the one question she had circled the week before. She rewrote it 6 times, each version slightly tighter than the last, cutting one unnecessary word, and then another, until what remained was exactly what it needed to be and nothing else. Then she put the pad away and did not look at it again before the hearing. She already knew it by heart. The final hearing was scheduled for 9 a.m. on a Tuesday in late November. By 8:30, every seat in the courtroom was filled. The 2 reporters who had attended previous sessions were back, joined by a third from the Columbus Dispatch, who had driven down after reading the Gazette's coverage of the evidentiary session. 6 current and former Meridian workers occupied the gallery's left side, 3 of them the same men who had been present 2 weeks earlier. 2 investigators from the Ohio OSHA division sat in plain clothes near the back wall, clipboards face down on their laps. Gloria Webb was in the second row, in the same navy dress she had worn to the second hearing, the pin with Leonard's photograph on her lapel. Justice Pemberton sat 1 seat to her left, both hands resting on the head of her cane. Charles Whitfield arrived at 8:55. He set his materials at the plaintiff's table without looking at anyone and poured coffee from his thermos. He was wearing black today. Whitfield called Robert Crane as his first and only witness. Crane was 53, with the comfortable tan of someone who had recently returned from a warm climate, and the handshake of a man practiced at projecting authority in rooms where money was being decided. He took the witness box with the ease of someone who had been there before, not in a courtroom specifically, but in high-stakes rooms, generally, and had learned that ease itself is a form of argument. Whitfield walked him through the standard framework. Crane's 11 years as vice president of operations, Meridian's safety review structure, the internal audit process for zone compliance, the general reliability of the inspection system that produced the March 1st report, then the waiver. Mr. Crane, the safety waiver bearing Leonard Webb's signature, is that document consistent with Meridian's standard protocol for high-risk zone access authorization? Completely standard. We've used that form for 15 years. And in your role overseeing operations, do you have any reason to question the authenticity of that document? None whatsoever. No further questions. Whitfield sat. He straightened his notes. He did not look at the defense table. Simone stood up. She carried nothing. No folder, no legal pad, no printed exhibits. She walked to the open space before the witness box, in the same clothes she had worn to every hearing, the burgundy blazer from Burlington, the dark slacks, the shoes she had borrowed from Gloria, because her own had a heel that had started to separate. She stopped 6 feet from Crane and looked at him for a moment without speaking. Mr. Crane. Good morning. Good morning. Your company's defense in this proceeding rests entirely on 2 documents, the safety inspection report dated March 1st, 2023, and the safety waiver dated November 18th, 2021. That is correct. Without those two documents, Meridian has no defense against the evidence that Zone B7 was in a known state of critical disrepair on the day my father died. Whitfield. Objection argumentative. Hollins, rephrase Ms. Webb. Without those two documents, Mr. Crane Meridian's legal position in this case is materially weakened. Correct. Those documents establish the facts as they occurred. Simone nodded once. I have just one question. The room went still in a way that courtrooms rarely go still, not the ordinary quiet of procedure, but the held-breath quiet of people who understand that something is about to change and cannot look away from it. Can you explain to this court how Gary Tatum, whose employment at Meridian Industrial was officially terminated on February 28, 2023, as confirmed by Ohio Department of Commerce, certified records signed a safety inspection report dated the following day, and how the safety waiver bearing my father's name was signed by a left-handed writer? When Leonard Webb signed every document in your company's possession for 22 years with his right hand. Robert Crane did not move. His mouth opened. It closed. His eyes moved to Whitfield, who was looking at the surface of his table. His eyes moved to Hollins, who was looking at him. His eyes moved back to Simone Webb, 26 years old, standing in borrowed shoes, and he understood in the specific and irreversible way that a person understands something they can no longer pretend they do not know, that there was no answer available to him that would not destroy something. Objection, Whitfield said. His voice was different now, flatter. Compound question. Assumes facts not in evidence. Hollins did not look at him. Both sets of evidence have been authenticated and admitted in prior sessions, Mr. Whitfield. Your objection is overruled. She turned to the witness box. Mr. Crane, answer the question. Crane looked at his hands. He looked at the ceiling. He looked at the gallery, and found 6 faces of men who had worked in his plant, who had filed work orders he had canceled, who had watched a colleague die in a zone he had chosen not to repair. He said nothing. The silence lasted 11 seconds. Everyone in the room counted it without meaning to. Your Honor, Simone said, her voice completely level. The defense moves for summary judgment in favor of the plaintiff and requests this matter be referred to the Ohio Attorney General's Office for criminal investigation into document fraud and obstruction of justice. Hollins called a recess. She was gone for 18 minutes. When she returned, her expression had this particular quality of someone who has made a decision and finished with the difficulty of making it. This court finds the plaintiff's motion for summary judgment well-founded. Meridian Industrial is found liable for the wrongful death of Leonard Webb. The March 1st inspection report and the November 18th safety waiver are hereby stricken from the record as fraudulent instruments. This matter is referred in full to the Ohio Attorney General's Office and the Federal Bureau of Investigation. She set down her pen. Furthermore, the conduct of plaintiff's counsel is referred to the Ohio State Bar Association for disciplinary review. The gavel came down. The 2 OSHA investigators rose from their seats before the sound had finished. One walked directly to Robert Crane. The other approached the defense table and spoke briefly to Whitfield, who remained seated and did not respond. A third investigator crossed to the defense table and looked at Darius. We'd like to speak with you and your family about 5 additional workplace incidents at Meridian between 2018 and 2022. Your father's safety complaints reference patterns consistent across all 5 cases. Darius looked at him for a moment. We've been waiting for someone to ask. Robert Crane was placed under arrest in the courthouse parking lot at 11:47 that morning. The charges were read to him beside an unmarked government vehicle, while a light rain began to fall on the Bridgeport pavement, criminal fraud, obstruction of justice, and conspiracy to falsify official safety documents. He did not resist. He did not speak. He stood with his hands behind his back and looked at the middle distance in the particular way of a man who has arrived at a moment he knew was coming and spent years pretending it wasn't. Charles Whitfield received his notice of temporary license suspension from the Ohio State Bar 3 days later by certified mail. His secretary signed for it. The suspension was pending a formal disciplinary hearing. 30 years, 61 jury wins, 3 law school textbooks with his name on the spine. Suspended by a letter delivered to a building he could no longer legally enter as a licensed attorney, Meridian Industrial's board convened an emergency session the following week. Their new legal team, the original 3 firms on retainer, had all quietly withdrawn, contacted Gloria Webb's household with a settlement offer of $4.7 million. The offer arrived by phone, not letter. The attorney on the line used the word appropriate 4 times in 2 minutes. Darius wrote the number on a notepad and passed it to his siblings. The 3 of them looked at it without speaking. Then they looked at Gloria. Gloria was quiet for a long moment. "Is this everything we asked for? Everything and more?" Simone said. Then it was never about the number. She signed the settlement agreement 2 days later at the kitchen table with the pen Leonard had kept in the junk drawer for 18 years. When it was done, she stood up, walked to the counter, picked up the original check for $47,500 that Meridian had brought to her door the week of the funeral, and tore it in half. Then she tore the halves again. She placed the 4 pieces on the counter beside the coffee maker and did not look at them again. The OSHA investigation expanded within 2 weeks. The 5 additional workplace incidents Darius had been briefed on in the courtroom were formally reopened. In 4 of the 5 cases, safety inspection reports had been signed by inspectors whose employment records showed termination dates preceding the report dates. The same pattern. The same stamp used after the same kind of departure. Leonard Webb had documented the beginning of it in his careful and unread complaints years before anyone with authority chose to look. 6 workers came forward in the month that followed men and women who had filed their own complaints about Zone B7 and other sections of the plant who had been told the issues were resolved, who had watched colleagues get injured and said nothing publicly because they needed the $19 an hour and the health insurance that came with it. They gave statements. They brought documents. One of them brought a printed email chain showing Crane explicitly instructing a facilities manager to reclassify a critical maintenance flag as routine. That email became the centerpiece of the criminal case against Crane. On a Saturday morning, 6 weeks after the verdict, Gloria answered a knock at the front door and found Gary Tatum standing on the porch with his hat in his hands. He was smaller than she had imagined from the text messages, a lean man in his late 50s, with the particular weathered look of someone who had been carrying something heavy for a long time. He said, "I should have done more when I was still inside that building. Your husband kept telling me those work orders needed to go through. I said I'd escalate. I didn't." Gloria studied him for a moment. Then she opened the door. "Come in," she said. "I'll make coffee." He stayed for 2 hours. When he left, he shook hands with Marcus at the door and could not quite meet his eyes. Marcus let him not meet them. Some things take more than one conversation to become bearable. Gloria's pension payments resumed the following month with full back payment for every withheld month, plus statutory interest. The total arrived in a single deposit. She transferred most of it into a savings account she opened in Leonard's name at the branch where he had banked for 20 years with the same teller who had known him since the early 2000s. The Triplets did not become lawyers. Darius continued his data work but began consulting pro bono for families navigating workers' compensation and wrongful death claims, building the kind of document chains and evidence spreadsheets that had saved his mother's case. Within a year, 3 labor attorneys in the Columbus area were referring clients to him before filing. Marcus started a channel on YouTube explaining industrial machinery failure in plain language. Why pressure valves fail, what sensor overrides do to a safety system, how to read a maintenance log for signs that someone is hiding a problem. Within 8 months, he had 40,000 subscribers, most of them plant workers and their families. Simone was accepted into Bridgeport State's Accelerated JD program in the spring, a 3-year path designed for candidates with significant legal experience who had not taken the traditional route. She started in September. On her first day, she brought her father's last safety complaint still in the plastic sleeve and put it in her bag. She has not taken it out, but she knows it is there. On a gray November morning, the 4 of them drove to Bridgeport Memorial Cemetery and stood before Leonard's headstone without a planned ceremony or prepared words. Gloria had brought nothing except herself. Marcus had brought nothing. Darius had brought nothing. Simone had brought one thing: a certified copy of Judge Hollins's summary judgment order printed on court letterhead, bearing the official seal. She placed it at the base of the stone. The wind moved it slightly. Nobody picked it up. They stood there together for a while, long enough that the cold became part of the moment, and then Gloria said he just needed someone to finish reading. They drove home without the radio on. Leonard Webb filed 11 safety complaints in 14 months. He described the problem precisely. He cited the right codes. He attached the evidence. He did everything a person is supposed to do when the system is working. The system was not working. What saved his family was not a credential or a title. It was 3 people who refused to accept that the truth needed permission to exist. You do not need a law degree to ask the right question. You need the courage to stand in the room and ask it anyway. If this story reached something in you, share it. There are families right now sitting at kitchen tables with documents nobody wants to read. Drop a word in the comments that tells us you stayed until the end. And if you want more stories about ordinary people who refused to stay quiet, subscribe. We'll be here.